realities of the dispute resolution options within the due process system. I think it's something that parents don't understand enough. At the same time, I don't think schools discuss it, even though it's contained within your parental rights that you're supposed to receive on a yearly basis. You are a valuable member of your child's IEP team. That is number one. You're sort of 50%, and when I say sort of, the goal is consensus. So if there's a lack of consensus on your child's IEP team, then at that point, what it should do is trigger one of the dispute resolution options. But it doesn't naturally trigger the dispute resolution options because you've got to do it as a parent. The school doesn't do it. So you can notate in your child's IEP that you disagree with the content, with what the child's program is for the next school year. It does not do anything. The school will still implement that IEP that you disagree with. And maybe you didn't voice your opinion. Maybe you didn't say anything. Maybe you were quiet. Maybe you were like, this stinks, but I don't want to look like the bad guy, or I don't want to poison my relationship, and I don't want to have people mad at me. There are different personality types in our world, guys. There's a lot of parents out there that they're not, A-type personalities that are just annoying like me, okay? I get that. I accept that about myself. But people like me are needed, just like people that are not that way, that are more reserved and quiet. We need all types in this world for it to work properly. We do. We need a variety of thought, of process, of personality. But understand that as a parent, we're dealing with our children here. And the school system has basic rules, guys, that if they followed that process, and it's not a complex process, but if they follow the process, then I can't tell you how easy it is to avoid due process and mediation requests. And so many times that process is not followed, either through ignorance or intentional gaming of the system, okay? To the point where lack of transparency, lying, deception, those kind of things tend to be the biggest problem, along with ignorance of administrators, mostly principals, that trigger these problems, these disputes. A parent sees those things, or maybe they don't because they've been deceived. When did you find out, though? And that's where it's important. Did you take action? Because I can't tell you how upsetting it is to us, the attorneys on my team, because, we feel you guys, we do as parents in fixing these problems. And we feel you when you feel like you've been betrayed year after year after year after year. Understand, though, that we have limitations within the special education legal parameter, that we have to balance everything on a reasonableness standard, that there are absolute requirements and rules on the public school to where they have a responsibility to provide your child with a free, appropriate public education every year. So as we're correcting your child's program or putting it on the path that it should have been the entire time, that consumes a lot of your child's school day. They're at school 6.5 hours a day, in large part. So where do we put the recovery services, the compensatory services? There is no money damages in special education law. So where do we insert that extra time that your child lost out on and that they're entitled to? There's only so much time in a school day. And by inserting all that extra time or compensatory time into your child's school day for a current school year, it messes with your child's least restrictive environment. Because those things have to be done sort of in a pull-out environment. The recovery services. So we can't really do that because we can't mess with your child's least restrictive environment and some of the parameters that are required in order for your child to receive a FAPE. So we have to identify other areas that we can insert that extra time to recovery services. Typically after school, during the summer mostly, or spread out over a couple school years. So we've got to get creative But this is where a lot of parents are like, but they've screwed my child for so many years. You have a 2-year statute of limitations in most states. North Carolina's 1 year. Even Texas went to 2 years. That's all you can go back, guys. But even going back that 2 years, and we do that frequently, there's a balancing to what you can recover because there's only so much given time. Where can you stick those things? And it is not an hour for hour, minute for minute recovery because we use a balancing of a reasonableness standard. And then you have the other expectations or the other things within the law that are also sort of natural limiting things. You don't have the power to fire people. That is something that's reserved for the public schools. So you need to be mindful of these things. Do not let these things fester and become toxic. Don't sit there and say, I'm going to give them another chance and another chance and another chance. If you know that it hasn't worked in the past. Don't ignore the signs. That's why I have this page, so we can raise your level of understanding and knowledge of this process, of what the expectations are, of what you need to be looking for with regards to an advocate for your child. If you are seeing these problems, then you have a responsibility to trigger your dispute resolution options. That's not the responsibility of the school system. Their requirements are to have an IEP meeting to where you're invited to participate. And consensus is going to be assumed unless you trigger your dispute resolution. Just signing that you disagree might be a marker that consensus didn't exist. And that would apply to your 2-year statute of limitations if the next school year you decide to sit there and file a due process. Then you can go back and go, you see, I didn't agree with this one either. And then that would be applicable to, let's say, a consideration in a due process hearing or in negotiations for settlement of recovery services. But just notating your disagreement alone without any further action doesn't do anything. The school's still going to implement that IEP. You have to go through the next step of triggering your dispute resolution options through requesting due process or requesting mediation or filing a state complaint. It just doesn't happen organically. The school's not going to do it for you. And I know that most parents are sitting there going, I don't want to sue my school. It's not really like that, guys. It's not suing your school. It's a different legal process. It's supposed to be collaborative. It's supposed to be working through simple disputes of programming. That's what it is. I'm an attorney, yes, but I specialize in solving problems. I specialize in identifying where the gaps are in the requirements of the school, in using services with regards to special education funding from the federal government and also contributions from the state government. That they're used in the way that they're intended, that your child has a program that is reasonably calculated to provide your child with a free, appropriate public education in light of his or her circumstances. That's the standard. It's not a death penalty case. If a judge doesn't agree with you, that's not like they take your child or your child just evaporates. That's not what happens. So you don't need to sit there and turn or magnify this process into something that's negative or more than what it really is. It is supposed to be and designed to be a collaborative process to resolve disputes and disagreements with regards to your child's education program. That's it. I assist in that area because I have an expertise in these rules and regulations where the law permits parents to obtain legal expertise in order to level the playing field with a school who has a board attorney, most of which also have an expertise in these rules and regulations. It's just balancing the playing field. I think it's a very, very smart, beneficial, positive thing that Congress put into this law of special education. but you can't be fearful to advocate for your child. Don't allow it to turn toxic. Don't allow it to fester. And I know a lot of parents sit there and go, well, you know, getting an attorney involved, you know, that is negative. No. Part of what we do is to fix those issues, to bring positivity back to your IEP team, to maintain your positive relationship. I can't tell you, if you let things fester and be toxic, you do more damage by not advocating for your child. Because now you've inserted suspicion, lack of trust. Everybody on the team can feel that, guys. Avoid that. Look at the process as it was intended. Advocate for your child in a timely fashion so that you stay within your 2-year statute and you don't have a buildup of year after year after year of damage to where it's not possible or feasible for us to design recovery services along with setting your child's program on a yearly basis to where it needs to be. Because there's only so much time in a day. There's only so much time in a year to insert recovery services or compensatory services for your child. We're limited on the reasonableness standard, guys. It's not an hour for hour, minute to minute transfer over or recovery. All right? So don't sit on these things. You can avoid a lot of heartache for yourself and in this process. And like I said, don't overthink the process. Don't magnify it into more than what it is and what it was intended. It's actually a positive process, or supposed to be.